want to thank our panelists, Judge Susan Braden sitting next to me, former Chief Judge of the Court of Federal Claims, and involved in a number of startup companies now. I think she'll have a lot to add to this. Kate Hudson from AAU, and then last and certainly not least, the Honorable Judge Paul Michel, former Chief Judge of the Court of Appeals for the Federal Circuit. We have a pretty active panel, so I'm going to kick it off quickly and start with a question I think Kate should answer first, but I'll leave it to everyone to talk about. So what is the Bayh-Dole Act of 1980? Why should people care?
Sure. The Bayh-Dole Act was a revolutionary piece of legislation passed in 1980 under the bipartisan leadership of Senators Bob Dole and Birch Bayh. These two gentlemen saw a problem with the way that research translation was not happening into commercialization with federally funded research and the patents that are a product of that federally funded research, namely at universities and nonprofits. Prior to 1980, those patents, when they were secured by the university, went back to Washington to the agency that had funded the grant, never to basically be seen from again, right? They put on a shelf, not commercialized, not developed, no further research and development. What the Bayh-Dole Act does is it changes that centralization, it decentralizes it, and leaves the intellectual property in the hands of the university, university or nonprofit who performed the federally funded research. Allowing that intellectual property to stay with them then incentivizes the university to seek private sector partners for further research and development with the aim of taking that early stage nascent or embryonic discovery or technology through the commercialization cycle itself. Without that change in the holding of the intellectual property, the system would have continued the same way it did prior to 1980. The Bayh-Dole Act really underlies so much of the groundswell of innovation that has happened in the United States since 1982 to present day, specifically taking off in about 1996 onwards. Once universities got the hang of translating and commercializing with their private sector partners, after about a decade or so, it really took off. So that's the existence of the Bayh-Dole Act. There is a component of the Bayh-Dole Act called march-in rights that allows the government to, quote unquote, march in when there is a case where either the university or the private sector partner are not furthering the development of that licensed technology. And there are 4 criteria for that march-in. This was, as our colleague Joe Allen describes it, kind of an emergency valve to step in instances of potential corporate gamesmanship where an incumbent is potentially disrupting or suppressing a potentially disruptive product to protect their own, and a couple of other cases. But march-in has never been used by the federal government, which is really an indication of honestly, the strength of everything that has come out of the Bayh-Dole Act since inception.
Josh, if I can add a point or two to that excellent summary, the secret weapon underneath the Bayh-Dole Act was the ability of the university to license to a commercial partner exclusively, because economically that turned out to be the key. Non-exclusive licenses were of interest to almost no commercial actors, so they wouldn't come in to commercialize and actually perfect and produce the product. So that was sort of the hidden weapon of it. The other thing to add to what Kate has so usefully said is that the Bayh-Dole aftermath was the creation of an enormous ecosystem of private companies collaborating with America's great research universities, of which we have scores and scores, not just a few famous ones, but scores and scores. And it's produced astonishing results, including tens of thousands of startups, new startups, millions and millions of new jobs, and trillions of added GDP. So the system obviously worked like crazy for 44 years. And there was never an occasion, as Kate said, when the Marchand rights had to be utilized, and they were asked for repeatedly, particularly regarding pharmaceuticals at NIH. And the bill's authors and Joe Allen, who carries the torch for them now that they're no longer with us, testified in front of NIH. And NIH turned down every Marchand application as not proper because it was based on price, which was never mentioned in the statute, and according to the authors and Joe Allen, was never contemplated or intended at all. So the fact that this proposal is even being made, to me, is astonishing, shocking, and bewildering. The system has been a total success. No problem has ever been shown with it. And the effect of the Marchand rights, if and when they're exercised by particular agencies, is to wreck this system and drive away all the commercial companies that would implement this wonderful upstream science research, the opposite of what our country needs.
Thank you, Kate, and thank you, Judge. I think that is important because when talking about challenges, I think it was this last year, right shortly before the guidance was issued, that there was a request, and this same administration that then put out the guidance said, no, it's not based on price. So let's get to the guidance. What actually is in the guidance? Why do we think it was put out there? What's the goals? Why won't it work? And that's a lot of questions, and we can start with what the guidance is first, and I'm open to whoever wants to start on that.
Well, look, this was a secret staff initiative. We don't know when exactly it was started, but what's interesting is that it was assigned to the National Institute of Standards and Technology, which is a very obscure little agency someplace out in the countryside of Maryland. All right? And they had a group of staff people there from different agencies, but interestingly, no one from the Patent Office was involved. No one from the Department of Education was involved. No one was involved with the Department of Agriculture, which is a huge area for the use of Bayh-Dole. No one from DOD and DARPA. No one from the National Academy of Sciences. No one from the National Institute of Health. Didn't they think any of those people had something to add or know something? These guidelines were popped out in, I think, late November, maybe even early December, right before the Christmas holidays, and the deadline was 60 days for comments. And they didn't extend it. There were lots of people who asked them. Normally, it's a no-brainer to have the government extend comment periods 60. I mean, you've seen the Patent Office, they extend them over and over again, okay? This was in my judgment, a crass political move. And it gets worse. Of all the comments, there are a lot of really good comments that were submitted in this thing, opposing it. But what was really interesting is IP Watchdog, who I really love their work, someone did some research. Of the 52,000 comments that were posted, 45,200 were robo-duplicates supporting this, including another couple thousand were identical submissions by the same person. And then there were comments from several foreign countries. Now, if you were there at lunch today, you heard me ask the director directly. I mean, the Patent Office, as I understand it, of all the patents that they issue each year, and Dave Kappas may be able to correct me on this if I don't have it, but between 25 and 30% of all patents granted by the USPTO receive some level of federal funding. So that means a good, 40% of the work of the agency is basically going to be under a cloud? Who is going to want to invest in these patents? Who's going to want to put the money to commercialize them if someone can come and say, a bureaucrat would say, oh, you know, I don't really like the price of whatever this is. based on my great expertise in the market, which is going to be zip. Okay, and they're going to come in and they're going to say, by the way, I know you've kind of built this company and you've got it, you've got shareholders and all this type of thing, but we're going to put all that at risk. And by the way, good luck. I mean, what type of chaos? What type of? I can't understand. I've said this before. I am convinced that we're going to destroy our own economy. We don't need to worry about the Chinese. We're going to do it all on our own before they ever get here. Now, I don't know if the people that are doing this, I assume they're well-meaning people, well-educated. They just think that our system is so corrupt and capitalist and that it needs to be torn apart for us to basically function as a democracy. Don't they know that in order to have a democracy, you have to have people who are employed. You have to have people putting money at risk and expecting a return on that risk. Otherwise, you're going to have people in the streets basically lined up for bread. So this is no small thing. This is the last program in this conference. But this effort is really cuts into the heart of our economy, and it's not. It's something serious. And I said to the director today, this needs to be shelved as an interesting staff experiment. And it needs to be done now, and she needs to tell the secretary to do it. This agency is under the secretary's authority. Her answer to me was something along the lines as, well, it's an all-in-government, approach to everything, which to me means basically this was a White House initiative, or some staff person thought this was a good idea. And the idea, I think, really was to show that they were going to lower drug prices, except the fools that they are, they didn't know that there are only 4, if I believe I'm right, Judge, 4 patents that even have, pharmaceutical patents that even have any education or federal government funding in it. So it's a farce. They're going after the very infrastructure in environment, semiconductors, and other things we're going to talk about later on. It's going to shock you to see how far-reaching these guidelines are into the manufacturing part of our economy. Sorry. You can tell I don't care much about this topic.
Let me add again a perspective from courts, which correctly, I think, focus on process. Is the process fair? This interagency group operated in secret. When the Chamber of Commerce tried to find out who was on it, they were stiff-armed and it was not disclosed. When the Chamber tried to find out, well, what was the analysis done among the members of this interagency secret task force? What was their data? What was their analysis? What were their conclusions? Again, no disclosure, stiff-arm. So right away, that makes me suspicious that they didn't have good analysis or any analysis, right, or a lot of data or maybe any data. So it's hard to not be cynical about what the motivation here might have been. It could be that the members of the task force were well-meaning people who were just under-informed or ill-informed. But it makes me worry that there were more nefarious motivations at work here. Obviously, if you read the headlines, the high cost of certain drugs and the problem of certain poor people of being able to afford medicines they need is front and center in the public discussion in this country. So I'm assuming, it's just speculation, of course, that people in the White House said, we have to show we're doing something about this. Whether we really do anything or not, we have to make a showing that we're doing something about this. So they issued this draft guidance. Of course, it doesn't do any harm technically because it's not enforced yet. No agency has implemented it, but it's already scaring away commercial actors, the ones we need to intervene more and produce more. They're being scared away by the uncertainty because no one is going to invest if their investment can be confiscated effectively by the government at a later date because somebody decides that the price is too high or the quantity available is too low. So this thing was ill-started and maybe ill-motivated, and it's so ironic that it'll have almost no effect on the actual price of drugs, which has been thoroughly documented in several very good studies, and the proponents of this proposal have no answer to the fact that it actually won't lower drug prices.
Thank you. And I think we'll have a bit more, actually, it may help now to talk a little bit about what the procedures would actually be for this, and how would they even figure out what the price should be if this actually went through, which I think it's very complicated, and I don't think we're going to have an answer today, but I think explaining the complexity.
Flip a coin. I don't like that price. That's the analysis.
Certainly in the draft guidance that was proposed, there were a number of new subjective criteria and terms that were pretty vague and not tied to other portions of the U.S. Code or federal regulations. So it was particularly distressing to see a regulatory document like this that doesn't draw upon that legal authority or legal foundation itself, and really left many open-ended questions to the subjectivity of those terms itself. So in terms of what this would look like in implementation, it's really hard to know. It could be wildly unpredictable. As draft guidance to the agencies, then the agencies would take it upon themselves to, in theory, implement pieces of this in their own policies. And as anyone who has spent any time working with government agencies, they all have their different standards for exactly the same thing, right? It's already a frustrating, disjointed, disconnected process that is not harmonized across the federal government. This just continues to feed into that lack of harmony. This in no way provides clear guidance to agencies to implement this. The funding agencies that have been working under the Bayh-Dole Act already have those criteria and those processes set forward, and it has worked for 44 years. This guidance did not do anything to clarify it where there was a lack of clarity before. Certainly, there are ways to improve Bayh-Dole, specifically on the compliance end, and to provide that guidance to universities and how to report those subject inventions, but that's not what any of the draft guidelines addressed themselves. So how it would look in implementation, that's the scary part of it, is that it is so uncertain and subjective and introduces elements that have never been considered before under March-in criteria. That is what is so damaging and dangerous about the draft guidelines themselves.
As a former federal judge, the words arbitrary and capricious come immediately to mind,
Yes.
not to mention vague and void. Not only Administrative Procedure Act, but constitutional challenges. This is a nightmare. They can't possibly have had even a first-year law student look at this without having someone look at it and say, my, this is going to be this will keep K Street busy for years. I mean, this is no way to run a government.
And of course, if implemented by any agency that gets a petition to march in and does march in, there'll immediately be a lawsuit. And the lawsuit will say, essentially, there's no authority in the Bayh-Dole Act to use price as a criterion for march-in. The march-in was only intended to cover when the licensee or the university was not taking steps to actually commercialize the research and come up with a product and get it into the market. That's never happened. And so this whole thing is kind of crazy. And in terms of who will decide that a price of a given drug or other thing, because it covers every technology, but just sticking for a minute with drugs, is too high. If I'm right that the initiative here came from political people, not legal people and not economic people, any price is going to be viewed as too high because somebody is going to complain they can't pay that price. So this vague term is going to turn out to be really pernicious as an excuse to confiscate licenses and destroy companies. And it's a pretense that it's doing something useful about the cost of drugs, which in some cases certainly is very high. The solution to the high cost is to fix the crazy system of healthcare finance that we have in this country, not to wreck the patent system or to destroy the Bayh-Dole magical apparatus that's produced so much.
By the way, anybody can file a petition under this to challenge somebody for March-N. Your competitor, shall we say, a foreign country, and putting up somebody else as a dummy. And there are no criteria. I mean, my grandson can file a petition, and that begins a whole government process that the universities are going to have to fund for I don't know how long before it even gets probably to a decision.
Yeah.
And that's going to be several. This is not going to happen quickly. This will be at least a year or more.
Oh, yeah.
Now, a year or more in any company's life, particularly a young company, is can kill that company, even a big company. And we've seen what's happened, like with big companies like, Northrop. I mean, any major disruption to a business of that magnitude can change the whole dynamics and can be terribly disruptive to the economies. And I want, Josh, you to get into the individual industries, because I want the audience to know how far-reaching this is into the industrial base of our country.
Yeah, we're going to get to the industries. I think got two more questions on margin. One, a somewhat long hypothetical, which I think is important in this case, even though I don't generally like long ones. So we've already said there are very few drugs where all the patents tie in. So there's very few things you could even challenge. And then, obviously, court challenges, even if you could go through. And as you just pointed out, you don't have to be a generic who wants to enter to do it. Anyone can challenge. But let's say it is. We've also had other panels today talk about how, there's lots of shortages with generics. It's hard to justify products, price. So even if you did all of that, is there any guarantee, if the license was free, that someone else would actually come in and be cheaper? Or is it all, for nothing, even in that rare case where you maybe actually get through everything? Is there a shot of this working at all?
That's really the farce of it, is that, this isn't a situation where, the government then produces whatever they've marched in on. They're going to find another licensee, and they're going to license the IP to them to go forward, which, depending upon where it has been in the cycle of research and development after it came off campus, this is not as though they'll be turning out whatever product it is, including drugs, in 6 months. That's not a guarantee. There's no guarantee that someone can step up and provide it at a cheaper price if that's what the actual desired outcome is. There are no guarantees around that. That's something that we haven't faced yet under March-In rights, because it's never happened before. But if we game it out, there are no guarantees. There is no predictability in that equation.
Also, you don't have to be so cynical to think that there were political and public relations motivations in the mix here. A lawyer at NIST told me that they were instructed that no change could be made to the guidance by their staff, because higher authority wanted the guidance to stay exactly the way it was. So that supports the thesis that this was a very political motivation coming presumably right out of the White House, not coincidentally in the year of a close re-election campaign. So I don't think you have to be very suspicious to think that there's something amiss here. And another thing that bothered me, again from a legal standpoint, is this is a total end run. This draft guidance is a total end run around the normal legal process, which would be for there to be notice of a proposed rulemaking, and then commentary, and then finalization of a rulemaking.
Hearings?
And hearings, and then legal tests as necessary. All that is being avoided by this technique of so-called guidance But if the understanding of the agencies is, well, it's called guidance, but you better do it or you're going to be in big trouble, then it has the force and effect of law as a practical matter, even though it's not challengeable the way things that formally have force and effect of law always are. So this is a legally dubious route to a bad result.
Thank you. Last question before we turn to larger industry effects. One thing the other side points out or brings up, and I think it deserves some clarification, is this whole paying twice issue, which I think is, if not outright a lie, certainly incomplete. So can we explain a little about what they're saying and what actually happened? Kate, I think from the university perspective, you probably have a lot to add here.
Yeah, the saying goes that you're paying twice for the same thing, that American taxpayers, when they have to buy these high-priced pharmaceuticals, are paying twice over, because first time they paid for the federal research that funds the discovery itself, and then they're paying at the pharmacy itself. Just wanted to level set, that's what the actual saying is. I try to push back on that as much as humanly possible. The amount of federal research dollars, which has been in steady decline for decades, if you look at it, the federal research dollars involved, while they represent a significant contribution to the scientific research enterprise across the United States, those billions of dollars in investment absolutely pale in comparison to the contributions of our private sector partners after the discovery is made. When the research grant agreement is fulfilled, right? The university has performed the research, the grant is over, the agreement is finished, right? The partner that takes it from there and inputs untold amounts of resources, capital, time, and development into it is on orders of magnitude greater than the federal contribution itself. The federal government funds fundamental research that is not able to be performed by private sector, right? We should reap the benefits of that fundamental research, but our private sector partners that bear the further risk and the further cost and billions of dollars of investment afterwards absolutely overshadows the federal contribution to that. We also see those funding levels continuing to diverge as you look at them longitudinally. Private R&D is just absolutely outpacing federal contributions to science research itself on the whole in American society, and it really operates from a place where that's just such a disingenuous thing to say. The amount of an individual taxpayer's dollars that go into federally funded research is probably fractions of pennies at most, right? And so you're not paying twice. You're not paying $5,000 for the same drug twice over. It's really a false statement, and I try to push back on that as much as possible because it doesn't represent a full picture of how innovation is commercialized in the United States.
Also, if you look at the specific terms of the guidance, if $1 of federal money supported a program at a university that resulted in a useful discovery as a matter of basic science, it's covered by the guidance, even if most of the money that supported that research came from private sources or university resources or elsewhere. So it's doubly not true that the taxpayers are paying for it twice. In many cases, they didn't pay for it the first time, except by some tiny fraction. So this thing is so badly written as to make you wonder, who approved this? Who vetted this? And as I mentioned, that's being hidden. No one is allowed to tell you who wrote it, what their analysis was, who approved it later. All we know is NIST was told, you better not change anything in here. So it looks to me like it's going to be treated as marching orders by agencies unless it's abandoned. by NIST on behalf of the administration, which I agree is really what needs to happen here.
Thank you. Let's talk a little bit about the industry effects. How many patents come out of universities? What industries are affected? We've already said it's broader than just life sciences, though there are a lot in the biopharma space. And what happens if university research goes away or universities can't transfer licenses to companies?
That would be me?
Sure.
Let me begin by just a quick follow-up on the venture capital. If you are successful in getting a patent, securing a patent, it's more than, it increases your chances of obtaining venture capital by 50%. Now that's a very important little star to stick on your talking points when you're going out to raise money. I have a patent. That may get somebody's attention. Let me talk about how deep this goes into our economy. From 81 to 2000, those are the statistics that I have. In biotech, this is not pharma, biotech, which includes health products, food, agriculture, some environment. There are over about 16,000 patents that are out there now that are at risk of being confiscated if someone with a GS-13 decides that the products being sold are not at a reasonable price. Let's go to semiconductors. There are about 7,000 semiconductor patents that are out there. 8,000 in computing equipment. These are ones that came from with federal funding. 9,000 in telecommunications. The last panel was really important to listen to about the number of patents that people have. So these figures that I have are out of date, but the most recent thing that I could find. The CHIPS Act has $13 billion to develop the next generation of computer chips. Why should any private industry contribute to this effort if their commercial products are subject to march-in? That's a hell of a good question. In manufacturing, additive manufacturing, metals manufacturing, electrical manufacturing, weapons manufacturing, which is a big business in this country, layered manufacturing products. You have probably about 20,000. Green energy. What's interesting there is that the lithium batteries that power electric vehicles that were first developed with Worcester Polytechnic Institute and were licensed to Ascend Elements in Kentucky, they were able to raise $1 billion last year for that technology, subject to patents. That's now all at risk. The import basically is that about 25% of our GDP is attributed to utility IP intensive industry. 90% of the value of all S&P 500 companies were attributed to intangible assets, and that doesn't include NASDAQ. Intensive industries comprise, patent industries or IP intensive industries comprise 41% of the United States economic output, increased by 34% in 2010, and over 44% of our national employment. That's what this document has put at risk. If that doesn't compel you to go to the polls, I don't know what would.
Let's talk about the importance of intellectual property on the U.S. standing in the international community.
Do you want to take that one, Judge Michel?
Well, that's your expertise.
Well, we already are at a comparative disadvantage vis-a-vis many commercial rivals in Europe, for example, and in other parts of the world, because They have faster, cheaper trials. They have stronger remedies for patent infringement. They issue injunctions routinely, which we used to do here, but now rarely do. So the background facts are we're already comparing poorly to many commercial rivals, and even to potential strategic rivals like China. Again, China routinely gives injunctions once infringement is proven. The trials are way faster and cheaper than here. There's no disruptive discovery there the way there is here. So the disparities are huge, and they show up when the Chamber of Commerce does its annual assessment of 55 or so more advanced countries around the globe, and comes up with rankings of who's best overall in innovation and who's best in patent enforcement and other categories like that. And for years and years, from the beginning of these annual surveys, the U.S. was #1 in all those categories. Well, we're no longer #1. At one point, we fell to tie for 10th. We've done a little better more recently, so now we're about 4th or 5th in the most critical category. But it's not encouraging how we compare with our rivals in those ratings or on a enforceability comparison. So as was suggested earlier, it makes you wonder if our country unintentionally is putting itself at a severe economic disadvantage and is going to suffer employment losses and GDP reductions and standard of living diminishment because we have such bad policies that are undermining our previously wildly successful U.S. patent system. It's just bizarre. And the change is so sudden. As recently as March of 2023, NIH turned down its 20th request to march in on products. So 1 year later, there's a flip, and now all of a sudden a march in is being proposed across the board, all technologies, all agencies. There are 22 agencies that do some grant work. So 22 different parts of the government are about to have this new weapon in their hand of marching in, confiscating exclusive patents. Why the sudden change? What changed? All those years under Republican and Democratic administrations, conservative and liberal, for 44 years, everybody agreed Bayh-Dole had nothing to do with price. And then all of a sudden, in an election year, Bayh-Dole is all about price.
If I may, we're truly on, in combination with some of the other misguided policies where we've ended up with intellectual property as a whole, we're truly on the knife's edge in the jeopardization of Bayh-Dole, in the sense that this is truly an American success story to the extent that 18 other countries have implemented a similar, almost identical model in their own innovation economies. That's how strong and how powerful over time this has been for U.S. society, and that has been observed by both our competitors and our allies who have implemented it. We are already falling behind in a number of critical technology areas, and if Bayh-Dole is jeopardized and uncertainty is created and cloud is put over and taint is put over any federally funded research coming off of a university campus, that will truly start to put nails in the coffin, and that decline will be marked. It will be very sharp, and it will be very observable if this is finalized and implemented. I know that sounds a little dramatic and histrionic, but it truly is when you see how successful it has been and such a huge factor in the development of our innovation economy in the last 44 years, that in combination with some of the political and policy struggles that are happening in the IP sphere itself, that combination is going to be really detrimental to the U.S.
One source of fundamental misunderstanding is, number one, critics assume innovation will happen anyway.
Yes.
Just magically fall out of the sky.
Yeah.
And number two, particularly lawyers are guilty of this, I suppose, IP lawyers particularly, patent lawyers the worst of all. it's not really about law. And in a way, it's not even really just about technological prowess. It's about money, because innovation is almost always highly expensive. It takes a long time. It's very risky. Many efforts fail. In the drug world, most efforts fail in the lab, and of those that succeed in the lab, most fail in the Food and Drug Administration clinical tests. So it's a very tough and very expensive environment for innovative companies, and this is in every industry. But the key thing to remember is it's very expensive, and therefore you've got to look at the incentives, and it applies equally to venture capitalists or private equity funds or other external funders, but it applies exactly the same way inside of a corporation. What CEO or CFO is going to risk huge amounts of the company money on something that can be confiscated from them after they've developed the product and spent all the money? It would be irresponsible. They would be in breach of their fiduciary duty to their stockholders. So they're not going to do it. So whether it's corporate or VC money that you're focused on, it's being disincentivized by this march-in guidance, and it's already starting to take an effect.
Thank you. Talking about the cloud, we've talked a lot about what happens if this actually goes through, but I think it's worth discussing what's happening by just being out there and what kind of cloud that creates and why it's not okay. I mean, it's certainly better to be out there than to be finalized, but it's not okay just to leave it as is. That doesn't solve the...
David Kappas has said that any one of his clients that would ask him about investing in a patent now that would had federal funding, he said, I believe the word he used was toxic. I think that says it all.
It's already having a chilling effect. Some of the licensing agreements that were in the pipeline, so to speak, have been put on hold. And every week and every month that this sits out there without being rescinded by NIST as the mother agency, that cloud just continues to darken. It does not inspire any kind of confidence. So it is having already a detrimental effect that we're seeing in our tech transfer offices.
But the full measured effect won't become clear for years because
Yes.
of the lag in collecting economic data and analyzing and reporting it. So we can already see there's damage starting to happen, but the full extent of the damage will be much worse, but we won't have all the evidence of that for some years. So is that a risk the country wants to take? The same thing with weapons and defense-related technologies. We want to make sacrifices to our ability to stay ahead of potential rivals in defense-related technologies. There's already one study, partly financed by the State Department, as I understand it, but performed by a very thorough think tank based in Australia that concluded in comparing our advanced technologies prowess with that of China. They concluded that of the 44 most advanced technologies, China was already now ahead of the United States in 37 of the 44. Now, maybe you can quibble with some of those figures. Maybe they're only a little bit ahead in this, a lot ahead in that, and maybe not quite up to us in something else. But the overall picture, whatever infirmities one may find in that study, is just appalling. According to that think tank, we're already falling behind China, and the gap is going to widen constantly unless we reverse almost every IP policy in this country.
Now, I think some other agencies have put out drafts suggesting a contractual way to deal with something somewhat similar, where if you take funding for it, you would agree to something on pricing. What are the panel's thoughts on that? There's the same problems that we're seeing here. Is there different problems? And hasn't this been tried before? And what happened when we've tried this before?
Yeah, well, we don't have to speculate about what would happen if March-In is fully implemented, because that's what we had for decades before 1980 when Bayh-Dole was enacted, and this whole new system was put into place that's become so hugely successful. And what happened was private industry largely avoided participating. So they didn't make the investment, they didn't do the work, and so as was pointed out by prior panels in this panel, most of the federally funded science research sat on the shelf and never got turned into products available for people to use. So we already know exactly what will happen if the Bayh-Dole system is upended. So it just makes it doubly worrisome that it's even being contemplated to do this, because we know the result. It's entirely predictable. We lived with it for decades.
Whether you like it or not, Google came out of Bayh-Dole.
Mm-hmm.
That should tell you a little bit about its impact.
NIH also experimented with this exact kind of reasonable pricing mechanism specifically. The new word that floats around in NPRMs and RFIs is accessibility plans, to be included in intramural research proposals. But you saw this with NIH experimenting with it specifically over, I believe, a six or 7 year time period, and the private sector applications for partnerships just absolutely tanked, to the extent that the NIH director completely scrapped it. I mean, they could see the data that quickly that it just, all of those applications took a nosedive, let alone the translational research that could have been done in that time period. So we have seen this. We saw this before 1980. We saw this movie at NIH itself, specifically in medical research. And so there's not too much of a jump to say that that's exactly what would happen if agencies start attempting to implement this in their own way and add reasonable pricing clauses into their research agreements.
Yeah, we understand from various sources that it's already spreading, that federal agencies, and as I said, there are 22 different ones that do some level of support of university research. It's already happening. That their agreements are requiring reasonable pricing, whatever that means, just the way the guidelines would. So I think what's happened is somebody figured out that the opposition to the guidelines was so huge that they might stall or be utterly rejected. So then a parallel route was pursued by the administration, apparently, to have the contracts with the universities have these fair pricing clauses in them, and then the guidelines wouldn't be needed. You get the same result by a different route.
I think we're going to turn to audience questions in a minute. So please line up if you have questions. And I hope, given we're at a university and there are some people who...
They want to know what you're serving at the bar. Let me interject before we lose the audience. The center is self-funded. It's not funded by the university. It's funded by you, donors, et cetera. And so if you feel compelled, to become part of this enterprise, I'm sure Josh will be in touch with you between now and the end of the year. And your thoughtful, generous contributions are tax deductible.
Thank you, Judge.
Yeah.
Okay.
John?
Hi, John Fargo. I was formerly DOJ, now semi-retired. A couple things, and thank you for the excellent, thumbnail of Bayh-Dole. I think prior to 1980, which we saw was sort of a diversity between the agencies, between what we call a title policy and a license policy. NIH would try, in some instances, to grant title and actually grant or approve not an exclusive license where it's necessary incentive to bring forth risk capital, the exact standard that Bayh-Dole had, but it was of questionable legality since it had no statutory basis, and it, I think, was challenged in Public Citizen versus Sampson. So what Bayh-Dole did was two things. It gave a clear statutory right to agencies to waive title and also grant exclusive licenses or have the title holder grant them. So I think those were the two things that were done. As I think Judge Braden pointed out, some GS-13 is going to make some determination that, one, there's a responsible applicant, because 203 only permits the grant of a license or compelling the university or title holder to grant a license to a responsible applicant. So it's going to have to determine it's a responsible applicant. Nothing in 203 says it's a free license. So what is a royalty? Because a reasonable royalty for a non-exclusive license, when the major consideration for the exclusive license was not the money, it was a commitment of risk capital.
Yeah.
It's got to do that. And there was such an extreme case that the invention was not being made available in reasonable terms to the public. All of that's reviewable by the Court of Federal Claims by statute. So what you've done is probably nothing in the short term except cost the company, the title holder, money.
Absolutely. That proceeding would be, I mean, and if you look at the, average lifespan of one of these petitions, 3+ years of research, time, personnel, things that, we could be spending in other ways on campuses. And certainly our private sector partners cannot afford that either.
And the non-exclusive, and the grant by the agency or by the compelled, but by the title holder is held in abeyance.
Yes.
Until it goes through all of the courts.
Yeah, and it talk about just a poison pill. So there's such an opportunity for bad actors, for bad intentions there, because the time is the most valuable part of that, right? And that exclusivity and the time under the patent term itself, that is also a harm that is done through these proceedings. Even if we come out on the other side and we win, we have lost so much.
And win in short order.
Oh yeah, absolutely, yes.
One other point on that, I think NIST, we've seen in the past, was tasked by Commerce to write regulations in areas where it was anybody's guess why. Where it didn't have any particular expertise.
Yeah.
We talked about the public paying. If I have a exclusive license from the University of Pennsylvania for some great pharmaceutical, and I spend billions to develop it, and then my license is effectively confiscated by the federal government, I'm going to sue the federal government in the U.S. Court of Claims, and I'm likely to win. And who is going to have to pay? The taxpayers are going to have to pay for this. So this is crazy from so many different angles in terms of what the monetary consequences are going to be and who's going to suffer the results.
Judge Braden, since we've been talking about your former court, do you want to comment on that at all? It ties into a little bit of something which we've worked on with other misguided drug pricing things in the past with 1498, but
That's another conference. First of all, litigation's a failure. Let's start there for number one. Number two, the Court of Federal Claims is incompetent to make a value judgment about what type of damages might result from any of this. And in any event, if they issued damages, and if the Federal Circuit ever supported them, guess who's paying for those damages? You are. It's a tax. It's a tax transfer. Why would they even think about going down that path? I'm sure all of you read the Food and Drug Law Journal on a regular basis by your bedside. But I wrote an article about 1498 and why it wasn't a prescription for drug prices. And Josh joined me on it and helped me get some students to proof what I wrote before it was published. But I'll explain you, why that's not going to work, okay? But even if it did, and it's a disaster. It's not worth serious discussion in my view. And it should never happen.
next question.
Thus saith the judge.
My name is Ryan Cavanis. I'm a first-year law student here at George Mason. I had a question for you, Judge Michel, about you were speaking about how the United States compared to Europe and even China has a distinct disadvantage in terms of our court system and being able to in patent litigation. Could you expand more on what the distinct disadvantages our court system has?
Well, it's very slow, it's very expensive, it's very disruptive, and often it's very unpredictable. Those are the very things that money people can't stand. And the money people are driving the system here, whether it's corporate money or venture capital money. So it's pretty simple. Lawyers need to learn a little bit more economics and business reality. So do judges, I must add. And if you're not paying attention to the flows of money, you're not really a serious student of what's going on.
Thank you very much, Judge. And I will, I'm sure it will please you to know that here at Scalia Law, we are all required to take law and economics. Thank you for your time.
Thank you. David.
Thank you, and I just wanted to echo Judge Braden's comments about the work you're doing here at SIP Squared. This has been a fantastic conference, and there's a reason why the Biotechnology Innovation Organization, among others, is so enthusiastic about participating in the work you do. So thank you very much for that. And thank you for making this panel the very last one. You kept me to the bitter end of this conference.
It's by design, David.
I mean, I work at the Biotechnology Innovation Organization, and we're more than 1,000 member companies involved in all aspects of biotechnology, and very often our companies are the counterparties to the universities who do the basic research. And it really does reflect something we do extraordinarily well in this country, which is translate basic research at the university lab bench to revolutionary cures at the patient's bedside. And we do more of that here in this country than the rest of the world combined. And the Bayh-Dole Act is one of the reasons we do it so well. But the irony here is that there are very few drugs where march-in would be an effective strategy because basic research institutions don't invent drugs.
Yes.
They discover pathways, they discover molecules that are developed further, and the most recent march-in petition for a cancer drug is illustrative of that. There was 3 patents, federal grants totaling about $150,000 that were then licensed to companies that spent another $2.4 billion to get it the rest of the way. And that's how that works. So yes, you will not be able to control prices because you can't claim all the relevant patents using march-in, but we are already seeing, to answer the question, a drop-off in collaboration. It is science that was paid for by the taxpayers that is not being developed into benefits for the public. And that's the real legacy of this, whether this ever is adopted finally or not. And that's the reality that we are looking at. Judge Braden, I know you've written on 1498, and you're right, that is another conversation. But just to close that out, advocates and certain members of Congress have now figured out that you can't control prices using march-in, and they are now turning to the blatant misuse of 1498 as a new strategy. And as my grandma used to say in situations like that, well, that's why God gave us federal judges.
Yeah, well, I've got my sights on Senator Sanders. I know about the letters.
Yes.
You know, for the moment, they're letters, and if the Senate changes, I think that will be the end of that discussion. Somebody from American Enterprise Institute has been on me all week to do something with her to publish, and I said, look, wait till the election's over. There's too much noise right now. If Trump wins, it's that issue, okay? If he doesn't, then it's everybody get your guns out and get them on deck and let's fire away, because it's gonna come fast. So I think, hold fire, till you see the whites of their eyes, and then we'll see what happens. But it will be a fight. And it'll be a fight that every person in this room needs to be a foot soldier in this, because what you're fighting about is not Republican, Democrat. What you're doing is you're fighting for the economy, which will save our democracy. All this chatter about democracy at risk, this is what makes democracy at risk.
Josh, you really have put together 2 days of an excellent intellectual exercise. I thought every speaker on every panel that I heard was absolutely a top expert, was extremely articulate and incisive. As my friend David Capo said, it's a pleasure to be here because of the quality of this conference that you put on every year. So great appreciation and salute to you.
Thank you very much, Judge. I see one more question has been waiting patiently, so I will let him ask that, and then I will thank the panelists, give a quick closing, and let everyone join us for cocktails.
Alexander Berinsky, Path Information Consultant. I subscribed for years for discussion list IP Health, which maintained by Knowledge Ecology International. It's non-profit which makes several campaigns for affordable medicine, and I know from this list for many years they filed petition to NIH to grant licenses to some drugs where was government contribution. And I'm not sure, maybe Kate, somebody clarify how this campaign, which go for years, brings this National Institute of Standard guidance. How is this related?
Right. So I think you were referring to KEI's Jamie Love's specifically multiple march-ins on the Xtandi drug, which is a prostate cancer drug that was developed off of federal funding to UCLA, which is one of my member institutions. It was funded by multiple. The discovery that led to Xtandi, I should say, was funded by multiple grants. One from NIH, and I believe the other was the Department of the Army. So how this plays in is that opponents, or I should say proponents of march-in, have been attempting to pierce the veil, if I can use a lawyer term, pierce the veil of march-in repeatedly on drugs that they thought could be exercised for, and they asked specifically on the basis of reasonable price. And not just quoting reasonable price, but saying that if it is not in practical use on reasonable terms to the public, that encompasses reasonable price. That's how they logically flow that, right, from it's not available on reasonable terms. That's how they derive the reasonable pricing aspect to that. So because Xtandi is a very expensive drug overall, the attempt was to have them march in on that one specifically because they knew the 3 patents, right, that lined up that would be subject to Bayh-Dole. In the latest petition, they obviously thought they were getting a favorable audience from this HHS secretary. If you did not know, Secretary Becerra, in his role in California, is a proponent of march-in and was a previous petitioner himself in concert with other government actors on march-in petitions. So I think that they thought they were getting a favorable audience that time around, and it was quashed. I mean, and they even asked for a rehearing of it, and it was quashed again. So the petition was not successful. The march-in guidance that we've been discussing comes out of that stakeholder community that have wanted march-in to be expanded and to add that criteria of reasonable pricing to it. They have been attempting for the better part of 20 years, starting with a law review article in 2004 out of Duke, with 2 law professors there that said, well, you could read that in. You could read in that reasonable pricing is part of the available on terms to the public, right? You could read that into it. And that was kind of taken up as potential legal wiggle room for that. But the draft guidance that's been put forward by the White House under the auspices of NIST is a reflection of the inroads that stakeholder community has made with the political class. So that's why you see it coming in this form. It's a calculated decision capable of evading review, but at least getting that criteria tossed into the water, so to speak, to test it out and see where it went from there. But it represents the first time that the government has said that that could be a criteria. And that's why we are so virulently against it, because it represents the first time that an official action went into that direction versus the petitions that have been struck down before. I hope that answers your question.
Oh, I won't. We have a couple minutes.
You know, let me just add, in a democracy, broad policy decisions are supposed to be made by the Congress, not by the courts and not by executive branch agencies. It was actually suggested to the Congress several times that the Bayh-Dole Act be amended to add a price control provision, and that was rejected.
Yeah.
So now we have an agency, NIST or a White House, take your pick, coming forward and saying they're going to do it anyway. In the face of the rejection by Congress to do that exact thing, I just think it's bizarre that any executive authorities purport to overrule Congress's determination.
Yeah, hi, I'm Dwayne Schultes. I'm the CEO of Vital Transformation. Our research has been quoted a couple times today. I just
Yes,
want
it has. Thank you, sir.
Yeah, I just want to clarify a couple points on that. Judge Braden had specifically made reference to it. We're the group that looked at the 3,000 patents of the 364 Type 1 FDA approvals. We researched those patents by origination. We looked specifically at where the origination took place. We knew where they were developed, and we also then searched manually for the government interest statement. So we're the ones that figured out how many of these actual patents. There were roughly 8 patents each for the 364 Type 1 FDA approvals, and of that group, we only found 5. I'll say that again. 5. That all the drugs had IP that was generated by grants. Well, in the case of medicines, that's specifically what we were looking for through the NIH. Now, of those 5, this is why it gets a little interesting. 2 of them were imaging agents of nominal value. One of the companies only, I think it recently sold, it's an imaging agent for Alzheimer's on a drug that's no longer used. So it sold for $1 million, means back of the envelope, the value of the company is about $100,000. 2 of the drugs were cancer drugs, no sales since 2018. Basically withdrawn from the market. The only drug that's in circulation is Xtandi. Yep. That's it. Yep. And it's ironic that the last 6 petitions have all been on Xtandi. It's the only drug that you can grab everything. Yep. That's it. So this is a political agenda. That's it. It was very interesting. I had a debate with Jamie Love when we published the study, and everyone was sort of, all hell was breaking loose, which was hilarious. And I finally just sat down and decided to tweet with Jamie Love. And he's like, well, what about this study that said, this drug came out, and this was Johns Hopkins University, and this should have been marched in? I'm like, oh, you mean the company that violated their patents, Johns Hopkins, went to the federal court and won, and then they filed the petition after they'd lost in federal court? That's the other case they're using. Yeah. There's nothing here. Yeah. I do have one quick question. Mm-hmm. Doesn't this run afoul of Chevron deference? I mean, isn't this exactly why the overrule of Chevron deference was put in place? Doesn't this violate all tenets of Chevron?
Well, let me take a quick answer to that. In the end, what statutes mean is decided by courts. That's our tradition, that's our law, that's the way we do it, that's the way we have to do it. And therefore, it's not up to an executive agency to say what the Bayh-Dole Act means vis-a-vis price. It's up to the courts. And I'm confident that if the courts were confronted directly with the question of can Bayh-Dole be used as a price control device, they would say, no, it's not in the statute anywhere under any reasonable interpretation.
I am not obviously as well versed as my esteemed colleagues here to either side of me, but I don't even think you get to a deference standard. The baseline violations of the APA Act, if we're talking just about the guidelines themselves, the baseline APA violations, in my opinion, would kill it. before you even get to talking about whether whether the agency is entitled to deference on it, and certainly not in this area. So, but yes, your instincts are right, though.
Okay, with that, I hope everyone can join me in thanking the panelists.